नमस्कार. आपण या ठिकाणी
As I
पाहू
start,
शकतोय
because I have one request. I want to maintain the
सुप्रीम
discipline of the
कोर्टात या
Constitution
ठिकाणी
bench. So
कामकाजाला
I am
सुरुवात
requesting your
झालेली
lordship to
आहे
give me 5
आणि
minutes. My
व्हायरल
lordship
मीडियावरती
assembles
याचं
at 3
थेट
o'clock
प्रक्षेपण
on
बघताय.
a most extraordinary urgent tension.
भारताचे
I won't do it now because
सन्माननीय
it's Constitution bench.
सरन्यायाधीश
The lordship is fortunately rising
रंजन
at
चंद्रचूड
2:55.
यांचं
So
या
I'll do
ठिकाणी
that
आगमन
before the
झालेलं
other
आहे.
starts.
मगाशी
And your
लंच
lordship will
ब्रेक
take it that
होता,
I am not
त्यानंतर
abusing the
पुन्हा
process.
एकदा
Your lordship hears what has happened.
कामकाजाला
That
सुरुवात
apart,
झाली आहे.
now
थेट
let
या
me
ठिकाणी
continue with this.
जाऊयात.
The mentioning is unrelated to this matter.
Unrelated.
Because I was only looking at
No,
the
unrelated.
point of view of the bench. Then Justice Narasimha and I will come back for the mentioning and then I'll assemble in the... Nothing to do with...
No, nothing to do with this.
White.
Agency.
Well, it's with your lordship's permission. Well, it's a senior person, well, it's in public life called Pawan Kheda was boarding a flight today at around 11 o'clock. At the flight, inside the flight, well, he was deboarded on well, 3 sets of complaints, Varanasi, Lucknow and Assam. The section invoked is 153A, 153B, national integration and enmity between groups. And well, based on a statement, I'm not at all justifying any statement. I may not use that language, you may not, but was based on a statement in a press conference and sought to be whisked away, at the moment they are at the airport. And being taken away by Assam police at Delhi airport. Therefore, till 3 o'clock they are there, and I'm showing that this cannot be a possible. We are asking for consolidation because now all over the country they are filing these FIRs. And with consolidation, this is stay of arrest. Stay of arrest.
Mr. Pawan Khera?
Mr. Pawan Kheda is a spokesperson of the Congress, and he has frequently had interactions with the press. He may, I will, for a moment, without going into the merits, have made a statement which many people would not make. Personally, I would not make. But the
What
statement,
you got?
I don't want to. I can repeat the statement,
We'll
but I
take it
don't
up.
want to repeat
We
it.
take it up at 3 o'clock or
That's all I'm saying.
3 o'clock is fine, no?
Yes, 3 o'clock.
Then, okay.
Please tell them till 3 o'clock. Yes,
Have you got some petitions?
yes, but we've got the provisional number. We'll have hopefully a diary number, but at least a provisional number in 3 sets.
All right.
Now, Miliz. Your lordships put that question just on rising. So let me answer, ABCD, that particular question. I'll continue with my sequence after, but lordship put that question, that had you allowed possibly the 30th vote to have worked itself out or other things, then your lordship would have had, so to say, an actual
Chetan,
test.
3 baje.
The courtmaster. Didn't come with the courtmaster. Now, Miliz, so therefore, you should have allowed that to happen, and then we would have had some idea, is what your lordship put in a nutshell. Miliz, there are 5 very interesting answers to it. Directly to your lordship, very important query. And Miliz, a related query of Justice Shah at that time. A, Miliz, this act was followed on 30th by the swearing in along with BJP persons. Just note, well, I'll make the point in a minute. Just note, 30th June was the swearing in along with senior members of the BJP. 3rd of July, 3 days later, the direct answer to my Lord's query, not on 30th, I agree. Nothing happened on 30th in terms of the vote. But exactly the same trust vote, if your lordship will call it, or a vote of a virtually identical nature happened at the speaker's election. Now clearly, there is a whip, there is a direction, you can't vote for the speaker, you are my party, you cannot vote. Voting was done. These 39 odd voted the other way. No proof is required. This is a 2-1B without going into a single fact. I'll give your lordship the judgments. Each of these acts your lordship has already held in judgments to be a direct violation of 10th schedule without any facts required. Well, if I vote for a speaker and I'm under a discipline of my party, you can't vote for him. You don't require anything else. You only need to see the voting Did I press that button or not? Nothing else is required to be seen. That is on 3rd. So what my lords is saying, nothing could change between 30th and 3rd. 3 days, well, no majority would change. No numbers would change. Then the third answer is the 4th of July. Again, an identical trust vote took place for Mr. Shinde. Again, you were told not to vote. Again, you voted. Same people, same vote, same system, same everything. 4th of July, a trust vote in the affirmative for Mr. Shinde. So my lord has ample proof. My lord rightly said, how will we know? We'll have to go into something. This is a very, very interesting case where 2-1B requires nothing, 2-1A also requires nothing. Normally, a lordship, 2-1B can be a per se completely, but something may be required for 2-1A. Here is a case where both 2-1A and 2-1B are per se. Very rare combination. 4th reason. So swearing in with the BJP, it's on cameras, everybody sees you. 3rd July speaker's election, 4th July trust vote of Mr. Shinde. Now what is the 4th reason? Even the acts, if your lordship were to go back, these are enough. I'm only giving by way of addition. I don't need to go back. I'm now giving your lordship the seemingly contentious issue, which is not actually contentious. The seemingly contentious issue, which is not contentious, is that on 21 and 22nd of June, you did not attend a meeting despite a direction in writing, please attend the meeting. The direction is on record, your non-attendance is on record, admitted. My lord will now look at it in demurrer. I'm trying to make it as simple as possible. No investigation, no inquiry, no evidence. Just look at it in demurrer. Second event is that you went with the BJP and others to meet the governor on 30th June. That's also admitted. It's on record, in the press, on photographs, on press reports. Admitted, no evidence required. As your lordship noted, this visit on 30th led to the swearing in which I have already mentioned. Now, which of these will not fall foul of 2-1A, forget 2-1B, Malus. 2-1B is more per se. Malus, what can be the defense? I'm asking myself hypothetically, Malus. Your lordship will also see the practical. Yes. I mean, what can be the defense? That these photographs are forged, all the media is forged. I was in Malus, Timbuktu, I never went to the governor's house. That can be a valid defense. Nobody's taken the defense, you can't. Now note 2 more interesting things, brothers. Rana, para 48. Lordship knows Rana very well, brothers, the Constitution bench. Specifically says that the act and conduct of going to a governor would constitute disqualification. That's Constitution bench. Citation the 2007 4 SCC 270 PDF page 834 of the first compilation.
It was read yesterday.
Only Malus para 48. So
Rajendra C. Rana.
I beg one?
Rajendra C. Rana.
Correct, Rajendra C. Rana. So Malus, this is very interesting again. The fact is admitted and the law is covered. What is it that a lordship has to do by way of an exercise is my question to myself. With great respect, nothing else. Fact is undeniable, admitted, and the law is covered. And covered too by a constitution bench. We are not saying, I can even bow down with great respect in a very contentious issue. Your lordship says, why should we not send it back? There is no issue here. Now note the second judgment, Srimant Patil gives a citation. Srimant Patil is the Karnataka judgment. Para 174 and 176. Para 174 and 176. The citation is 2020, volume 2 SCC 595. 3 learned judges. This is the
2020.
2020 2 SCC 595. The PDF page in the first law compilation is 1249. It's starting page, I'm sorry. The relevant para is 174 and 176. At PDF page 1307 and 1308. This holds the second point. Not attending meetings is culpable. This is the inception. 21st June and 22nd June you didn't attend meetings. This judgment holds that not attending meetings is sufficient to disqualify. So, in this 5 sets of facts are admitted, law is covered. Now, you can always say that we want to do this, but if there is a purity and a social and a political evil to be controlled by 10 children, then this requires no adjudication of any kind except the formality of a notice and looking into it. And what is it, even till today, what can be the defense of this? I am prepared to accept a new defense today. There cannot be a defense to these things. This is the light of, but I had finished on subject 2. Putting to you notice and risk on your own risk and cost, telling you in advance, warning you. Now, kindly consider, why is this principle? It is, for what the phrase my Lord is used time and again, the majesty of the law. It is not an empty rhetoric. Imagine, how much strengthened the rule of law is when your lordships in a rightful case does not one but 2 or 3 things. One, your lordships accepts fallibility. There is a line of cases of actus curiae that we were wrong. Justice Bhagwati, in a case I must thank my learned friend Mr. Shibble to point it out, said to accept fallibility is no act of heroism. So, then the consequence of accepting fallibility must follow. Otherwise, accepting of fallibility is empty. So, your lordship is now coalescing these principles, actus curiae, ibi ius, etc. Imagine, the strengthening of the rule of law when your lordship says, demolish this building even though we believe it's going to cause a lot of misery. The last one your lordship did took almost 6 months under your lordship supervision because 3 dates were extended. I believe my Lord Justice, Chief Justice was on the bench. But it happened because your lordship had a finding, had a view of the merits. And your lordship said, restoration of status quo ante is vital for the necessity for the majesty of law. Now, just see 2 striking examples in the 10th schedule when your lordships did this. We have talked about, but we haven't shown that actual para. It will tell lordships against what odds your lordship still said, no, we must uphold the law. Nabam Rebia first and Rajendra Singh Rana second. And this is not at all an upholding of Nabam Rebia. We are challenging Nabam Rebia on the sole point of disabling. The fact that I rely on Nabam Rebia for this doesn't at all, I'm entitled not to be hit by a stopple on that at all. Now kindly turn.
उद्धव ठाकरेंनी या ठिकाणी बहुमत चाचणीला सामोरं जाऊन या ठिकाणी सर्वच्या सर्व गोष्टी पटलावरती सभागृहाच्या आणायला पाहिजे होत्या असं विधान या ठिकाणी भारताचे सरन्यायाधीश धनंजय चंद्रचूड यांनी केलेलं आहे. याचं लाईव्ह प्रक्षेपण आपण व्हायरल इंडियाच्या माध्यमातून थेट बघतोय. या ठिकाणी अभिषेक मनु संघवी हे ठाकरे गटाचे वकील आहेत आणि त्यांचा युक्तिवाद सध्या या ठिकाणी जोरदारपणे चालू झालेला आहे. थेट या ठिकाणी आपण जाण्याचा प्रयत्न करूयात.
Decide howsoever severe the consequences. Let's kindly see this now. 214.1 is at iPad, PDF page 1158. 1158, first volume, the compilation first volume. My Lord has seen, but this part my Lord has not seen. This alone vindicates the rule of law. This alone vindicates the strength of the court system, not only the apex court. And this sends a clear message that, howsoever high or whatever the consequence, the consequence must flow if your lordship is convinced. Now, there could be no more scrambled egg in the context of 10th schedule than Navam Rebia. Your lordships unscrambled it. Please see 214.1. The order of the governor of 9th of December 2015, preponing the 6th session of the Arunachal Legislative Assembly from 14th January to 16th December of previous year 2015, is violative of Article 163, read with 174, and as such is liable to be quashed. The same is accordingly hereby quashed. I'll skip the next one, come to the next after next. 214.3. Now this is even more important. Well, remember, time had elapsed in between. Navam Rebia was decided on, give me the date. This is important, the date is important. 13th July. 13th July 2016 is the decision. So the first page. 13th July 2016. These events related to almost 8 months earlier. New government had come in. It was very easy to say so many things and not do this. But the court, if I may say, did the right thing in terms of consequence. All steps and decisions taken by the Arunachal Pradesh Legislative Assembly pursuant to the governor's order and message of 9/12/15 are unsustainable in view of the decisions at 214.1 and 214.2. The same are accordingly set aside. It was argued, as is argued frequently, that even if your lordship holds it illegal, the intervening decisions will not be set aside. Your lordship hears those arguments every day from this side of the bar or whatever. But this is, if I may say, it's the constitutional walking of the talk in case, once your lordship is convinced. Next, in view of the decision at paras point 1 and point 3 above, the status quo ante as it prevailed on 15/12/15 is ordered to be restored. That's 8 months earlier. That's why the date of 13th July versus the date of December 15, there's a hiatus of 8 months. A lot has happened in 8 months, while most of all the government is changed. Otherwise, all these principles, etc., will remain paper principles. Now, in Rajendra Singh Rana, the matter was more directly addressed as a juristic principle about you decide or send it back to the speaker. So that's my next case. Rana is 2007 4 SCC 270. First bunch compilation of case law, PDF page 834. And I will read, with your lordship's permission, paras 12, 44, 45, and 52, 53. It has nothing to do with the law. It is to do with once your lordship is convinced, what is the consequence? It's ibi jus, ibi remedium. It is actus cure. It is consequence. It is subject to. It is warning. All that is the point I am reading on.
What page did you say was that, please?
The page starts, the judgment start, para 12 is at PDF page 849. 834, the case starts. Here the argument was made squarely, that kindly decide. And the rival argument was don't decide. Let the speaker decide. The respondents, may I read this? The respondents in the writ petition, the MLAs constituting 37 BSP members who left the party, are the appellants in all the appeals, except the appeal arising out of the special leave petition filed by the writ petitioner Moria. Whereas the respondents in the writ petition, challenging the decision of the majority of the bench, remitting the matter to the speaker, the writ petitioner in his appeal challenges the order of remand to the speaker. The writ petition order of remand made by the majority on a plea that on the pleadings and the material available, the High Court ought to have straightaway allowed the petition filed by the writ petitioner for disqualification of the 13 MLAs. So squarely the issue is joined. Now come to 43. 44, I think. 44 at page 865. Normally, and if I may say so, the contentious issues in this case would be far, far more than the contentious issues in my case. Far, far more. Normally, this court might not proceed to take a decision for the first time when the authority concerned has not taken a decision in the eye of the law. And this court would normally remit the matter to the authority for taking a proper decision in accordance with law. And the decision of this court itself takes on the relevant aspects. What is urged on behalf of the Bahujan Samaj Party is that these 37 MLAs, except a few, have all been made ministers. And if they are guilty of defection, with reference to the date of defection, they have been holding office without authority in defiance of democratic principles, and in such a situation, this court must take a decision on the question of disqualification immediately. Well, my case has one chief minister, forget ministers. One amongst them is the chief minister, many are ministers. It is also submitted that the term of the assembly is coming to an end, and expeditious decision by this court was warranted for protection of the constitutional scheme and constitutional values. We find considerable force in this submission. This is what the Constitution Bench is saying. Here, the alleged act of disqualification of 13 MLAs took place on 27th of August. And well, this is only 13. We are 39 in this case. 42 actually, one of the 3 independents also. When they met the governor and requested him to call the leader of the opposition to form the government, the petition seeking disqualification of these 13 members based on that action of theirs has been allowed to drag on till now. It is not necessary for us to consider or comment on who was responsible for such delay. But the fact remains that the term of the Legislative Assembly that was constituted after the elections in February 2002 is coming to an end on the expiry of 5 years. A remand of the proceeding to the Speaker or our affirming the order of remand.
या ठिकाणी अध्यक्ष निवड आणि एकनाथ शिंदेच्या सरकारच्या विश्वासदर्शक ठरावावेळी व्हीपचं उल्लंघन झालंय असा युक्तिवाद ठाकरे गटाचे वकील अभिषेक मनु संघवी यांनी या ठिकाणी सुप्रीम कोर्टात बोलताना केलाय. त्यांचा युक्तिवाद सध्या लाईव्ह चालू आहे. अध्यक्ष निवडीवेळी अध्यक्ष निवड, विधानसभा अध्यक्ष निवड आणि एकनाथ शिंदेच्या विश्वासदर्शक ठरावावेळी व्हीपचं उल्लंघन झालंय असा युक्तिवाद सिंघवी यांनी या ठिकाणी सुप्रीम कोर्टात या ठिकाणी केलेला.
Though for the purpose of this case, the scope of that paragraph is involved. So, this case involved para 3. In my case, the lordship doesn't even have para 3. What adjudication is required? Rana involved the pre-existing non-deleted 3. With great respect, considering that if the 13 members are found to be disqualified, their continuance in the assembly, even for a day, would be illegal and unconstitutional. And their holding of the office as ministers would also be illegal, at least after the expiry of 6 months from the date of their taking charge of the office of ministers. We think that the court is bound to protect the Constitution and its values and the principles of democracy, which is a basic feature of the Constitution. This court has to take a decision. Now, this is important. This court has to take a decision one way or the other on the question of disqualification of the 13 MLAs based on their action in August 2003. Lastly, para 52 and 53, where they conclude finally on the result, on the factual result and the result of the case. As we have indicated, para 52 above, para 52 is 869. As we've indicated, nothing is produced to show that there was a split in the original political party on 26th August, as belatedly put forward in a later point of time. But still the plea of split was on 26/8. Now that question the Lordship doesn't have to headache about, no problem. On the materials, the only possible inference in the circumstance of the case is that it has not been proved, even prima facie, by the MLAs sought to be disqualified, that there was any split in the original political party of August 2003 as claimed by them. The necessary consequence would be that the 24 members who later joined the 13 could also not establish a split in the original political party as having taken place on 26th of August. In fact, even a split involving 37 MLAs is not established. There it was in two batches there. That was also the inference rightly drawn by the learned Chief Justice. In view of our conclusion, in view of our conclusion that it is necessary not only to show that 37 MLAs had separated, but it is also necessary to show that there was a split in the original political party. The above finding necessarily leads to the conclusion that the 13 MLAs sought to be disqualified had not established a defense or answer to the charge of defection under para 2 on the basis of para 3. The 13 MLAs therefore stand disqualified with effect from August 2003 Supreme Court finding directly at placetum E. The very giving of a letter to the governor requesting him to call the leader of the opposition to form a government by them itself would amount to their voluntarily giving up the membership of their party. Here they went ahead, they went with the BJP to the governor, in my case today. If so, the conclusion is irresistible that the 13 members of the BSP who met the governor in August 03, who are respondents so-and-so in the writ petition filed by Moria, stand disqualified in terms of 191, read with para 2, with effect from 27th August. If so, the appeal filed by the writ petitioner has to be allowed, even while dismissing the appeals filed by the 37 MLAs by modifying the decision of the majority of the division bench. Hence, the writ petition filed will stand allowed with the declaration that the 13 members who met the governor on so-and-so, being respondents so-and-so in the writ petition, stand disqualified from the UP Assembly with effect from August 2003. The appeals are dismissed. This is really, if I may say so with great respect, the right approach for the very existence and raison d'etre of 10th schedule and for the majesty of the law. And no other court can have more powers in this regard than your Lordship's court. Now, let me turn to some of the quotations. Now it will be more focused in terms of just quoting from some judgments. Kindly take a note, we go to the note now. Kindly take a note I have filed.
Already circulated?
A3. It's been sent. It's been sent in the night.
When you
Serial number is
serial number A3. I'm
there. It's there. It's there.
A3. It says brief written submission. My name is there for this.
Yes, it is there.
Lordship, I put the date for today because there are earlier submissions. This date is today's date. Although filed last night, I believe.
Made today?
Yes, it covers.
So what do I?
Except, I'm going to add one or two cases, as I've got only two cases, that you also will write in the note itself. Because the problem is it's a ever incoming wisdom every minute. May I read?
या ठिकाणी जोरदार युक्तिवाद असा सुप्रीम कोर्टात या ठिकाणी चालू आहे. अपात्रतेचा निर्णय आज जर झाला तरी सरकार बनल्यापासून लागू व्हावा असं महत्वपूर्ण विधान या ठिकाणी उद्धव ठाकरे गटाचे वकील, ज्येष्ठ वकील अभिषेक मनु संघवी या ठिकाणी करतायत. व्हायरल इंडियाच्या माध्यमातून आपण सुप्रीम कोर्टाचं थेट कामकाज एक्सक्लुझिव्ह आणि पहिल्यांदाच या ठिकाणी बघत आहात. अगोदरच्या काही वर्षांपासून आपल्याला हे कामकाज दिसत नव्हतं, परंतु आता थेट प्रक्षेपण आपल्याला दिसतंय आणि ठाकरे विरुद्ध शिंदे या दोन्ही गटाची सुनावणी, सत्ता संघर्षाची सुनावणी सध्या चालू आहे आणि याचं लाईव्ह प्रक्षेपण तुम्ही थेट आता बघताय. अपात्रतेचा निर्णय आज जर झाला तर सरकार म्हणल्यापासून तो लागू व्हावा असं अभिषेक मनु सिंघवी यांनी विधान केलेलं आहे.
It's important. It's a constitutional bench. The consequence of change of government happened fundamentally because the speaker was disabled, fettered in the interim from discharging his constitutional duties. The aforesaid disabling with the order of 27th of June was clearly contrary to a 5-judge bench in Quixote. I have read that para, Lordship will remember that, 110. Then it disturbed the co-equal and mutual balance between judicial and legislative organs, the latter represented by the Honorable Deputy Speaker. Contrary to detailed Supreme Court judgments, I have quoted them below, they are coming. These are only the bullets, giving Lordship the propositions. The orders of 27-6 and 29-6 cumulatively and conjointly were not orders merely
If you had warned us forewarned us that you've put it down in writing, I wouldn't have been trying my typing skills, I've typed exactly all this that you have mentioned.
But some of this is not going to be there in terms of answer to my Lord's query. The answers to your Lordship's query would have been oral, therefore.
Right.
Anyway, so I'll skip. Now there are two principles here which I have not mentioned orally. I'll skip till J, Lordship. Come to K, K. Then I'll skip again L and M. K is important. I'm sorry, J and K, both are important. J also. If in fact an illegality has occurred, and especially after fair warning through subject to orders, the court's powers and arms are always long enough to unravel any situation, and fait accompli cannot be a defense. That's the point. Then K is extremely important, because purposive interpretation. Your Lordships have interpreted 10th schedule purposively to plug all collateral and subsidiary loopholes also. Directly it is not said, but we find 20 ways of circumventing 10th schedule. Your Lordship says, I will interpret purposively to prevent that circumvention. That judgment will come also. The principle of purposive, in light of repeated and comprehensive exhortations by diverse constitution benches and the legislative travaux préparatoire underlying the object behind the 10th schedule and the mischief it sought to remedy, necessitates a purposive interpretation in a holistic perspective to fulfill the true object and spirit of the 10th schedule and not allow it to be rendered a dead letter or an exercise in futility. Then L is Nabam, M is Rana. Right, Now, just you can skip para 1 in Chauhan's case. The first line of the boldface Lordship may note, it is trite law that neither the governor nor for that matter this court has the power to impinge upon the authority of the speaker to take a decision. This is the co-equal aspect. Apart from the Quixote, no injunction aspect. So this judgment the Lordship will note, Justice Chandrachud and Justice Gupta's judgment. Thus, the principle of respecting the field of functioning of each constitutional functionary requires the court not to interdict either the disqualification proceedings before the speaker or the proceedings in the house. However, in the present case, that I'll skip. Then Quixote, 125 and 126. This is not that 110. 125, just turn to for a minute, it's in PDF 140 of the first complex.
That's okay, we can read it from here.
Yes.
You can read it out and then go to 120.
Well, this is 126. I'll also just add in hand 125 is important also. I forgot to put that. Just note that. The purpose of interlocutory orders is to preserve in status quo the rights of the parties so that proceedings do not become infructuous by any unilateral overtax by one side or the other. Then was Samir Bhojwani, a judgment to which my Lord, the Honorable Chief Justice of the party, though authored by Justice Khanvilkar, 2018. Distinction between molding of relief and granting of mandatory relief held that interim relief can be granted only to restore the status quo and not to establish a new set of things different from the state which existed at the date when the suit was instituted. You created a new status quo that's very different from maintaining a status quo.
Yes.
Then was Bommai in para 8. Para 115, it has, however, to be made clear, this is 3 judges out of the 7, and it's part of the concurring. It is, however, to be made clear that the interlocutory relief that may be granted to such challenge to prevent the frustration of the constitutional remedy. It is not to prevent the constitutional authority from exercising its powers and discharging its functions. This is even more important than Quixote. This is the origin of Quixote in the 10th schedule. Bommai was not 10th schedule, but the principle is important. And this is one of 7 judges. No, 9 judges. 9 judges. 9 judges, and this is the principle which Quixote applied to the 10th schedule. Our conclusion that Justice Savan's judgment is part of the majority, core majority. Our conclusions therefore may be summarized under, if the proclamation issued is held invalid, then notwithstanding the fact that it is approved by both houses of parliament, kindly note this, it will be open to the court to restore the status quo ante to the issuance of the proclamation and hence to restore the assembly and the ministry. In appropriate cases, the court will have power by an interim injunction to restrain the holding of fresh elections to the assembly, pending the final disposal of the challenge to the validity of the proclamation to avoid fait accompli and the remedy of judicial review being rendered fruitless. Whereas Mr. Hegde never saw to live to see this benefit because governments changed twice over by the time.
या ठिकाणी आपण बघतोय अभिषेक मनु सिंघवी सध्या युक्तिवाद करतात आहे आणि त्यांनी महत्वाचा असा युक्तिवाद केलेला आहे. एकनाथ शिंदेंनी भाजप सोबत सरकार स्थापण्यासाठी राज्यपालांकडे जाणं हेच कृत्य त्यांच्या अपात्रतेस कारणीभूत ठरू शकतं असा महत्वाचा युक्तिवाद अभिषेक मनु सिंघवी यांनी या ठिकाणी केलेला आहे. आपण याची लाईव्ह दृश्य बघतोय कामकाजाची. सिंघवींकडून पुन्हा एकदा या ठिकाणी नबाम रेबिया केसचा दाखला या ठिकाणी देण्यात आलेला आहे आणि त्यांचा युक्तिवाद सुप्रीम कोर्टात या ठिकाणी चालू आहे. भारताचे सरन्यायाधीश आणि त्यांच्या शेजारी आहेत खंडपीठाचे या ठिकाणी न्यायाधीश आणि त्यांच्या समोर या ठिकाणी भारताचे सरन्यायाधीश धनंजय चंद्रचूड यांच्या खंडपीठासमोर या प्रकरणाची सुनाई सध्या थेट चालू आहे. आपण याची दृश्य थेट बघू शकताय.
144 minutes. This is the but for test. Restore the parties to the position in which they would have occupied but for such decree or part thereof. The but for test it is called. Nor indeed that this duty or jurisdiction arise merely under the said section. It is inherent in the general jurisdiction of the court to act rightly and fairly according to circumstances. Then, Manus, they consider the submission. I'll skip that. Come to the end of Manus, that para 23. It's a long para. The boldface is sufficient, Manus. That such a thing was achieved by an ex parte order tends to shake the litigant's face in the judicial process. That, Manus, will not apply. Navam Rebia, I will skip. Now, Manus, here, before your lordship comes to the object, that is para 13 onwards, there are two important judgments your lordship will note. One is Manus Bhullar. This is not there. Lordship may note it down on the side, these three judgments. This is not there, Manus. No, but my proposition is not there. Your lordship may, it's not cited here. Manus, first is Bhullar, Devendra Bhullar, the death convict case. 2011-14 SCC 770. It's the PDF 926 and the relevant paras are 107 and 108. Please turn to that. Well, if there is an initial wrong, the court says, I'm sorry, 107 and 108. It's a very important principle. Kindly turn to Malu's PDF page 967 in the first compilation. Right? First compilation. 966.
What's the proposition?
If the Malu's initial wrong is found, then all consequential things must be adjusted so as to rectify that initial wrong. And second sentence is very important. This principle applies equally to judicial orders. This is very important. Please turn to 107, 108. Para number. Which page? 107 is at page 966. Put it here. It is a settled legal proposition that if the initial action is not in consonance with law, I'm sorry, does my lord have it? My lord doesn't have it. It's on substantial and consequential action. Well, the page is 966 bottom. It is a settled proposition of law that if initial action is not in consonance with law, all subsequent and consequential proceedings would fall through for the reason that illegality strikes at the root of the order. In such a situation, the legal maxim, it is given there, meaning thereby that the foundation has been removed, structure, work, falls, comes into play and applies on all scores. Now, the next para is more important. Next para. In Badrinath and Kerala, this court observed that once the basis of a proceeding is gone, all consequential acts, actions, orders would fall to the ground automatically, and this principle will apply to judicial, quasi-judicial and administrative proceedings equally. This is the meaning of majesty of the lawman. Well, I'll just take a little bit of time on Tuesday, but I won't take very long.
Rice? On Tuesday.
Very deeply of life.
कायद्याचं संरक्षण व्हायलाच हवं असं या ठिकाणी ठाकरे गटाचे वकील यांचं सुनावणी दरम्यान वक्तव्य या ठिकाणी समोर आलेलं आहे. महाराष्ट्रातल्या सत्ता संघर्षावरती सुनावणी या ठिकाणी चालू आहे. घटनापीठाचं कामकाज आज फक्त 3 वाजेपर्यंत चालणार होतं आणि आजचं कामकाज या ठिकाणी संपलेलं आहे. 3 वाजता पवन खेरा प्रकरणाची सुनावणी होणार आहे आणि त्यामुळे अर्थातच सत्ता संघर्षाची सुनावणी या ठिकाणी लाईव्ह प्रक्षेपण आपण बघतोय व्हायरल इंडियाच्या माध्यमातून. थेट या ठिकाणी सिंघवींकडून पुन्हा एकदा नबाम रेबिया केसचा दाखला देण्यात आलेला आहे आणि त्यांचा युक्तिवाद या ठिकाणी चालू आहे. घटनापीठाचं कामकाज आज 3 वाजेपर्यंत चालणार आहे. त्यामुळे अर्थातच 3 वाजल्यानंतर पवन खेरा प्रकरणाची सुनावणी या ठिकाणी होणार आहे. तर या ठिकाणी व्हायरल इंडियाच्या माध्यमातून थेट प्रश्न आम्ही उपस्थित करतोय. तुमचा पाठिंबा कोणाला आहे? मुख्यमंत्री एकनाथ शिंदे की उद्धव ठाकरे? तुमचा पाठिंबा कोणाला आहे? अवघ्या महाराष्ट्रच नव्हे तर जगभरातून कमेंट्स आपल्याला या ठिकाणी येत आहेत, कारण हजारो लाखो प्रेक्षक हे सध्या लाईव्ह प्रक्षेपण संपूर्णपणे बघतात. तुमचा पाठिंबा कोणाला आहे? उद्धव ठाकरे की एकनाथ शिंदे? कमेंट मध्ये या ठिकाणी कमेंट करून नक्की सांगा तुमचा पाठिंबा कोणाला. या ठिकाणी आपण थेट प्रक्षेपण बघतोय, लाईव्ह दृश्य आपण बघतोय. तुमचा पाठिंबा कोणाला आहे? सर्वात महत्वाची घडामोड या ठिकाणी सुप्रीम कोर्टात घडलेली आहे. आज अभिषेक मनु सिंघवी यांनी युक्तिवाद केलेला आहे आणि आपण थेट दृश्य या ठिकाणी बघू शकताय. संपूर्ण महाराष्ट्र हे लाईव्ह प्रक्षेपण बघतोय, त्यामुळे अर्थातच तुम्ही देखील तुमचं मत कमेंट बॉक्स मध्ये व्यक्त करू शकता आणि सर्वांना विनंती आहे की अपडेट रहा, कनेक्ट रहा व्हायरल इंडिया सोबत. घटनापीठाचं कामकाज आजच्या दिवसाचं संपूर्णपणे संपन्न झालेलं आहे आणि 3 वाजल्यानंतर आता 3 वाजलेले आहेत. यानंतर पवन खेरा प्रकरणाची सुनावणी या ठिकाणी होणार आहे आणि महाराष्ट्रातील सत्ता संघर्षाचा उर्वरित युक्तिवाद हा पुढील आठवड्यात होण्याची शक्यता आहे, कारण आपल्याला माहिती आहे शनिवार रविवार कोर्टाला साप्ताहिक सुट्टी असते. अर्थात त्यामुळे हे प्रकरण कदाचित घटनापीठाकडे येण्याची शक्यता कमी आहे. त्यामुळे कदाचित पुढच्या आठवड्यात हे प्रकरण पुन्हा एकदा बोर्डावरती हेअरिंगसाठी येऊ शकतं. आपण बघतोय लाईव्ह दृश्य बघतोय महाराष्ट्राच्या सत्ता संघर्षाची सुनावणी या ठिकाणी चालू आहे आणि लाईव्ह दृश्य आपण बघतोय. आपण बघतोय थेट प्रक्षेपण. आपण बघतोय महत्वाची या ठिकाणी सुनावणी दरम्यानची ही या ठिकाणी जे आज सुनावणी झाली सुप्रीम कोर्टात, त्या ठिकाणी तुमच्या विरोधात 39 आमदारांनी कुठेही मतदान केलेलं नाही. अभिषेक मनु सिंघवी यांच्या समोर युक्तिवादात सरन्यायाधीश चंद्रचूड म्हणतात, तुमच्या विरोधात 39 आमदारांनी कुठेही मतदान केलेलं नाहीये. तुम्ही बहुमत चाचणीला सुद्धा पुढे गेलेल्या नाही आहात. आम्ही काय करायचं, आम्ही काय करावं असा सवालच थेट भारताचे सरन्यायाधीश चंद्रचूड यांनी उपस्थित केलेला आहे. एक्सक्लुझिव्ह दृश्य आपण या ठिकाणी बघतोय ब्रेकिंग न्यूजच्या माध्यमातून. अभिषेक मनु सिंघवी हे ठाकरे गटाचे वकील आणि त्यांनी आज त्यांचा युक्तिवाद होता, परंतु 3 वाजल्यानंतर कामकाज थांबवलेलं आहे. कारण 3 वाजल्यानंतर सर्वोच्च न्यायालयात घटनापीठापुढे पवन खेरा प्रकरणाची सुनावणी होणार आहे. अर्थातच महाराष्ट्रातल्या सत्ता संघर्षाची सुनावणी युक्तिवाद कधी होणार हा देखील प्रश्न आहे. उद्या होतोय का हे देखील पाहावं लागणार आहे किंवा पुढील आठवड्यातच अर्थातच होण्याची शक्यता आहे. लाईव्ह दृश्य आपण बघतोय. तुम्ही राजीनामा दिल्यानं अधिकार गमावला आहे. आम्ही परिस्थिती जैसे थे कशी करणार. अर्थातच हे उद्धव ठाकरेंनाच विधान केलेलं आहे. उद्धव ठाकरे यांनी मुख्यमंत्री पदाचा कोणत्याही बहुमत चाचणीला सामोरं न जाता या ठिकाणी राजीनामा दिला होता आणि त्यामुळे धनंजय चंद्रचूड असा सवाल करत आहेत, उद्धव ठाकरे तुम्ही राजीनामा दिल्यानं अधिकार गमावला, आम्ही परिस्थिती जैसे थे कशी करणार, असा खडा सवालच सरन्यायाधीश धनंजय चंद्रचूड यांनी केलेला आहे. तीन दिवस ही सलग सुनावणी चालू होती आणि अखेर सर्वोच्च न्यायालयानं पुढची तारीख दिलेली आहे 28 फेब्रुवारीला. या प्रकरणाची सुनावणी होणार आहे. महाराष्ट्रातील सत्ता संघर्षाची सुनावणी या ठिकाणी 28 फेब्रुवारीला होणार आहे. आपल्या सर्वांसाठी महत्वाची या ठिकाणी ब्रेकिंग न्यूज आम्ही देतोय. महाराष्ट्रातल्या सत्ता संघर्षाची सुनावणी थेट आता 28 फेब्रुवारीला म्हणजे मंगळवारी या ठिकाणी होणार आहे. या ठिकाणी 3 दिवस खल झाला, परंतु शिंदे ठाकरेंना कोर्टानं पुढची तारीख दिलेली आहे. राज्याच्या सत्ता संघर्षात सलग 3 दिवस युक्तिवाद झाला, मात्र अद्यापही फक्त ठाकरे गटाचाच युक्तिवाद चालू आहे. कपिल सिब्बल असतील, अभिषेक मनु सिंघवी असतील, हे ठाकरे गटाचे वकील आहेत आणि त्यांचाच युक्तिवाद सध्या चालू आहे. एकनाथ शिंदे यांच्या गटाच्या वतीनं अजूनपर्यंत बाजू मांडण्यात आलेली नाही. त्यामुळे कोर्टानं अखेर 28 फेब्रुवारीची तारीख दिलेली आहे आणि आज 3 वाजल्यानंतर कामकाज त्यांनी थांबवलं आणि 3 वाजल्यापासून पवन खेरा प्रकरणाची सुनावणी या घटनापीठाकडे असणार आहे. आणि आपण याची एक्सक्लुझिव्ह ब्रेकिंग न्यूज आपल्या व्हायरल इंडियाच्या माध्यमातून बघत आहात. उर्वरित सुनावणी ही 28 फेब्रुवारी पासून सुरू होणार आहे. यावेळी ठाकरे गट आपला युक्तिवाद पूर्ण करेल आणि त्यानंतर मुख्यमंत्री एकनाथ शिंदे यांची बाजू मांडण्यात येणार आहे. त्यामुळे सत्ता संघर्षाची सुनावणी काही दिवस तरी पुढे ढकलली गेलेली आहे. सध्याची सर्वात महत्वाची अशी ब्रेकिंग न्यूज आहे. 3 दिवस या ठिकाणी खल झाला, परंतु कोर्टानं अखेर या ठिकाणी पुढची तारीख दिलेली आहे 28 फेब्रुवारी. शिंदे ठाकरे गटाची पुढील सुनावणी 28 फेब्रुवारीला होणार आहे. परंतु आजच चिंचवड विधानसभा मतदारसंघासाठी भारतीय जनता पार्टीचे वरिष्ठ नेते आणि महाराष्ट्र राज्याचे उपमुख्यमंत्री श्री देवेंद्र फडणवीस यांची सभा अश्विनी लक्ष्मण जगताप यांच्या प्रचारार्थ सांगवी पुणे या ठिकाणी आज पार पडणार आहे. संध्याकाळी 7:15 वाजल्यापासून आपण याचं थेट प्रक्षेपण आपल्या व्हायरल इंडियाच्या माध्यमातून पाहू शकता. शिंदे ठाकरे गटासाठी या ठिकाणी पुढची तारीख 28 फेब्रुवारी दिलेली आहे. त्यावरती काही भाष्य करतायत का? आज जो कपिल सिब्बल असतील किंवा अभिषेक मनु सिंघवी असतील यांनी जो युक्तिवाद जो आज कोर्टात या ठिकाणी केला, या सतत संघर्षावरती देवेंद्र फडणवीस काय भाष्य करतायत का हे देखील आपल्याला बघायचंय. महत्वाची सभा आहे, निवडणुकीचं वातावरण पेटलेलं आहे आणि त्याचंच कव्हरेज आपण काही वेळातच आपल्या व्हायरल इंडियाच्या माध्यमातून पाहू शकणार आहात. या लाईव्ह प्रक्षेपण पाहण्यासाठी तुम्ही तुमचा अमूल्य वेळ दिलात त्याबद्दल तुमचं मनापासून आभार. भेटूयात पुन्हा एकदा महाराष्ट्राच्या मराठी मातीतल्या तुमच्या व्हायरल इंडियावर. तोपर्यंत तुम्ही तुमची काळजी घ्या आणि अर्थातच सबस्क्राईब करा व्हायरल इंडियाला. नोटिफिकेशन तुम्हाला जर येत नसतील तर नोटिफिकेशन साठी बेल आयकॉन तुम्हाला तिथे घंटेचं एक बटन दिसेल चॅनेलच्या शेजारी, त्यावरती क्लिक करून तुम्ही सर्व अपडेट्स, लाईव्ह अपडेट्स घेऊ शकणार आहात. इतरही आमचे व्हिडिओज पाहायचे राहून गेले असतील तर आता लगेच जा, व्हिडिओ पहा, तुमचं मत कमेंट बॉक्समध्ये या ठिकाणी व्यक्त व्हा, कारण लोकशाहीनं तुम्हाला दिलेला हा सर्वोच्च अधिकार आहे. तर धन्यवाद. या लाईव्ह प्रक्षेपण पाहण्यासाठी तुम्ही तुमचा वेळ दिला त्याबद्दल मनापासून आभार. भेटूयात पुन्हा एकदा. तोपर्यंत काळजी घ्या तुमची आणि तुमच्या परिवाराची. धन्यवाद. जय हिंद, जय महाराष्ट्र.